All right, welcome back. Got a treat for you tonight. Well, I'm recording at night. This is going to go out early in the morning. So this morning, it's the long-awaited, long-promised delete Lawz versus Las Vegas Metropolitan Police Department. His new lawsuit about his recent arrest in Las Vegas. This is a cold read. I haven't looked at the lawsuit at all yet. I've pulled it up in my browser, let it load, but that's it. This is a cold read, so I haven't prepared any analysis. I have pulled up a few things that I think he's going to talk about. Uh, Specifically, I have tabs open for the Fourth Amendment, 14th Amendment, 42 USC 1983, and 18 USC 241, which 242 would also come up if he brings that up. There might be others. I don't know. He might not bring these ones up. We'll see. Also, in what turned out to be very fortuitous timing, my new mic finally arrived. So it's getting its cherry popped on this load of nonsense. So whoopee. So hopefully the sound is good on it. So with that, I figure most of you have been here before. If you are new, I'm Joe. I'm an attorney based in Utah. So he's inching closer to my jurisdiction with his lawsuits, but he's not quite here yet. So with that, let's jump into it. So, as always, we start with the docket. We have Decastro versus Las Vegas Metropolitan Police Department, as I mentioned. And thus far, we have the complaint, which is docket number 2. This was assigned to Judge Andrew P. Gordon and Magistrate Judge Elena J. Yucha. I'm not sure how to pronounce her last name. Summons has been issued to Brandon Bork, C. Dingle Doolittle, Las Vegas Metropolitan Police Department, Jesse Sandoval, B. Sorensen, State of Nevada, Jason Torrey, regarding the complaint. An advisory letter about electronic service. And apparently, I don't know if this is a smart move for him or not, but he has moved for access to file electronically. So he's asked for ECF access, which he's going to get. He's filed by ECF in the Massachusetts lawsuit. He just recently asked for access in the Ironton lawsuit, which not having it has worked to his advantage to some extent, because it's been dismissed twice and he's been able to say, well, me no receive documents. So because he doesn't monitor his mailing address, he's claimed, well, I didn't receive the documents, so you can't dismiss it. So he doesn't have that excuse this time. So presumably this lawsuit won't last the year that the Ironton lawsuit has, which for most people is good news. For me, it might not be, because I like easy content and there's no easy content that gets views for me, quite like Delete Lawz and his lawsuits. So, with that, let's jump in to the complaint. In the United States District Court for the District of Nevada, Jose Decastro versus Las Vegas Metropolitan Police Department, State of Nevada, Brandon Bork, Jason Torrey, C. Dingle, B. Sorensen, Jesse Sandoval, Officer Doolittle, and Does 1 to 50 inclusive. I think he just gets into habits, and his habit is 50 John Does. Who they are, I have no idea. Who they could be, I'm sure he doesn't have an idea, but this is a complaint for damages and demand for jury trial. Introduction. Plaintiff, a member of the press who specifically records police interactions, was recording a police officer interaction outside of a Rollin' Smoke barbecue in southwest Las Vegas, Nevada. 5 Las Vegas Metropolitan police officers, from now on I'm just going to say Vegas police or Vegas officers, including the officer that he was recording, under the guise of protecting the privacy of another citizen in public without reasonable suspicion that the plaintiff was involved in any criminal activity, did interfere with and rob a plaintiff of his liberties while he was in a place that he was lawfully allowed to be, while plaintiff was performing constitutionally protected activities. The officers detained plaintiff, handcuffed, arrested, battered, tortured, forced him into the back of a patrol vehicle, and searched him and his possessions. None of the defendants intervened to prevent the unreasonable detention, arrest, battery, torture, or searches. I mean, I've got news for you, Sunshine. You were engaged in criminal activity. I mean that it's like he's trying to play an Uno reverse card. The police interfered and robbed Delete Lawz of his liberties. He was interfering with their traffic stop. They said, go ahead and record. Just step back. You're too close. He refused. We've seen the video. I mean, if you're here, I'm not going to play the video, but if you're here, I'm sure you've seen the video now from multiple angles. We've seen his live stream. Recently, we've seen the police body cam. If you haven't seen it, Artie's Corporate Fiction did a FOIA request, and he's received multiple body camera angles. I've watched most of those. I have not watched the enhanced audio versions that some other people have enhanced the audio of. I've just seen the raw footage provided by Artie. So if you haven't watched those, go watch as soon as you're done here. It'll add a lot more context. At Artie's Corporate Fiction, go, like, subscribe, share his videos. He's entertaining. Sadly, the abusive treatment plaintiff endured for merely asserting his rights and recording the police is not unusual or surprising. This civil rights action seeks to vindicate plaintiff's constitutional and statutory rights and hold the officers and their department accountable for biased policing practices and the policies, or absence of policies, that resulted in these practices. Parties. Plaintiff Jose Decastro is an adult over the age of 18, a member of the press, and at all times relevant hereto was and is a resident of the state of California. Defendant, Las Vegas Metropolitan Police Department, LVMPD, is a quasi-municipal entity and a political subdivision of the state of Nevada, created and regulated by NRS Chapter 258, and at all times relevant hereto, employed all the individually named defendants. What he says, it's a quasi municipal entity. Exactly what makes it quasi municipal? I mean, it is municipal. It's I mean, like I said, I'm in Salt Lake City, not Las Vegas. My sister lived in Las Vegas for a while, but Las Vegas is kind of funny because, as I'm sure you all know, this isn't some super secret knowledge. Most of what we know as Las Vegas is not Las Vegas. Las Vegas is relatively small. Clark County is basically municipal Las Vegas. So, like, the Strip is technically in the unincorporated Clark County area known as Paradise, Nevada, although everything would have Las Vegas, Nevada as its mailing address. So, I'm guessing Las Vegas Metropolitan Police Department is either run by the agglomeration, sort of all of the cities within the metropolitan area fund it, and it's the overarching police, or it's Clark County, but not the Clark County Sheriff's Office. So it it's still so I don't know if it's, like I said, if it's part of the executive branch of Las Vegas or Clark County or of all of the Las Vegas metropolitan cities and unincorporated county area, part of their executive branch, sort of with overseen by the executive branches of all of those. That's a long-winded way of saying, yes, it is municipal. It's not quasi-municipal. It just might be overseen by more than one municipality. But I'm not going to look it up. Defendant State of Nevada is a government entity and at all times relevant hereto operates overseas and manages defendant LVMPD under the color of state law. Defendant Brandon Bork is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Bork was acting under the color of state law and in the course and scope of his employment with Nevada. Bork is sued in his individual capacity. Yeah, and that's going to be kicked out real fast because, in spite of Delete Lawz saying qualified immunity is not the problem, Terry versus Ohio is the problem, Officer Bork has qualified immunity as a police officer. So do all the other defendants, but defendant Jason Torrey is, and at all relevant times was, a supervisor with the LVMPD. In doing the things herein alleged, Torrey was acting under color of state law and in the course and scope of his employment with Nevada. Torrey is sued in his individual capacity, including in his capacity as a supervisor. His individual capacity isn't as a supervisor. I mean, Torrey is sued in his individual and official capacity, including as a supervisor, but that's just nitpicking. The defendant C. Dingle, what an unfortunate name, Dingle, is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Dingle was acting under the color of state law and in the course and scope of his employment with Nevada. Dingle is sued in his individual capacity. Plaintiff does not know the full true name of C. Dingle. Defendant B. Sorensen is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Sorensen was acting under the color of state law, and in the course and scope of his employment with Nevada. Sorensen is sued in his individual capacity. Plaintiff does not know the full true name of B. Sorensen. Defendant Jesse Sandoval is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Sandoval was acting under the color of state law and in the course and scope of his employment with Nevada. Sandoval is sued in his individual capacity. Defendant Officer Doolittle is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Doolittle was acting under the color of state law and in the course and scope of his employment with Nevada. Doolittle is sued in his individual capacity. Plaintiff does not know the full name of Officer Doolittle. The true names and capacities, whether individual, corporate, associate, or otherwise, of defendants sued herein, as does 1 through 50, inclusive, are unknown to plaintiff, who therefore sues said defendants by such fictitious names. Plaintiffs will amend this complaint to show the true names and capacities if and when the same are ascertained. Plaintiff is informed and believes and thereon alleges that said defendants and each of them are responsible in some manner for plaintiff's damages as herein alleged. Each reference in this complaint to defendant, defendants, or a specifically named defendant also refers to all Doe defendants. But how are there Doe defendants? I mean, is he trying to allege the chief? He could know the name of the chief very easily. Is he including the IA officer that he wiretapped, allegedly? Probably. Plaintiff is informed and believes, and thereon alleges, that each of the defendants sued herein was negligently, wrongfully, and otherwise responsible in some manner for the events and happenings as hereinafter described, and proximately caused injuries and damages to plaintiff. Further, one or more Doe defendants was at all material times responsible for the hiring, training, supervision, and discipline of other defendants, including the individually named and Doe defendants. Plaintiff is informed and believes, and thereon alleges that at all times herein mentioned, each of the defendants, including all defendants sued under fictitious names, was the agent and or employee of each of the other defendants, and in doing the things hereinafter alleged, was acting within the course and scope of such agency and employment. He still doesn't understand agency law in the slightest. Yes, the officers are acting as agents, employee agents of the Las Vegas Metropolitan Police Department. They are not each other's agents. That is not how it works. Plaintiff is informed and believes, and thereon alleges, that at all times herein mentioned, each of the defendants, including all defendants sued under fictitious names, was the... Did he repeat that? Paragraphs 14 and 15 are exactly the same, except for an added comma after the alleged on the last line of the paragraph. That's some good legal writing. Plaintiff is informed and believes, and thereon alleges, that each of the defendants was at all material times an agent, servant, employee, partner, joint venturer, co-conspirator, and or alter ego of the remaining defendants, and in doing the things herein alleged, was acting within the course and scope of that relationship. Plaintiff is further informed and believes, and thereon alleges, that each of the defendants herein gave consent, aid, and assistance to each of the remaining defendants, and ratified and or authorized the acts or omissions of each defendant as alleged herein, except as may be hereinafter otherwise specifically alleged. At all material times, each defendant was an integral participant, jointly engaged in constitutionally violative, unlawful, and or tortious activity, resulting in the deprivation of plaintiffs' constitutional rights and other actionable harm. At all material times, each defendant acted under color of state laws, statutes, ordinances, and regulations of the state of Nevada. He has lost his mind. He's lost his mind. He needs to lay off the silly sauce or powdered forms. The cops are employees of the other cops and joint venturers and partners, and the sovereign citizens love going to Black's Law Dictionary. They think the definition of things from the dictionary is the be all end all. Each of these things has a definition in the law, not just in Black's Law Dictionary. And every one of these is misapplied. I'm speechless. This is just dumb. Jurisdiction and venue. This court has jurisdiction over this action pursuant to 28 U.S.C. 1331 and 1343 A3 and 4 because it arises under the Constitution and laws of the United States, as it is being brought to obtain compensatory and punitive damages for the deprivation under color of law, state law, of the rights of a citizen of the United States that are secured by the United States Constitution, pursuant to 42 U.S.C. 1981, 1983, and 1988. This court has supplemental jurisdiction over the claims arising under Nevada law, pursuant to 28 U.S.C. 1367A. This court is the proper venue pursuant to 28 U.S.C. 1391B2 because the events giving rise to the claims occurred in the county of Clark in Nevada, which is in the U.S. District of Nevada. General factual allegations. At approximately 4:30 p.m. Pacific on March 15th, 2023, plaintiff happened upon a police interaction between a woman sitting in a silver Hyundai Elantra and Bork, who was sitting in a Ford Police Interceptor with the LVMPD logo on it and the number 19084. Plaintiff does not know the woman's name, but will refer to her as Jane. Plaintiff started recording the police interaction on one of his phones, moved to a position approximately 10 feet away from Jane, and making sure not to become between Bork and Jane, he asked her if she was good. Are you okay? And that's interfering with the police stop. Within 6 seconds, Bork left his vehicle, got plaintiff's attention, and told him to back up, which plaintiff immediately did, giving Bork an additional 5 feet. We have seen the video. He exaggeratedly took teeny tiny itsy bitsy steps back. It did not look like 5 feet to me. Furthermore, Officer Bork did not say, move 5 feet back. He said, move back. Until Officer Bork was satisfied, he had not complied. Bork told plaintiff to back up again, or he would detain plaintiff, at which time plaintiff began asserting his rights to record the interaction, saying, I'm more than 10 feet away. I'm a member of the press. I have a right to be here. Bork threatened to detain plaintiff for obstructing and said, she deserves privacy. This is not your business. Plaintiff continued to assert his rights and notified Bork that plaintiff was a member of the press, at which time Bork got upset and said that he was detaining plaintiff. What Delete Lawz still doesn't seem to understand, being a member of the press does not give you access to things you wouldn't otherwise have access to. If you would not be allowed that close to the traffic stop without a camera, you're not allowed that close with a camera. And you'll notice the officer never said, "Stop recording, you're not allowed to record." He said, "Move back." Bork told Jane to leave and started walking aggressively toward plaintiff, as if to use force, and plaintiff took a step back to prevent any physical confrontation. He started walking toward you because you were being detained. Plaintiff continued to protest Bork putting his hands on him unnecessarily, but Bork was patently uninterested in patently interested, in manhandling plaintiff in some way, and said, "Listen, I am going to put my hands on you." Bork did indeed batter plaintiff. Battery is the unlawful and unwanted touching. Arresting or detaining, as at this point it was detaining, is not battery. While plaintiff was firm in his verbal tone, he never screamed or yelled. He never threatened defendants and never said or did anything that would have led a reasonable law enforcement officer to fear for their safety or to suspect that plaintiff committed or was planning on committing any crime. You already committed the crime. You already interfered in the traffic stop. Plaintiff asked for a supervisor, and while continuing to protest against illegal detainment and against the use of unnecessary force, plaintiff offered to walk to Bork's vehicle, which seemed to be where the officer wanted to illegally detain plaintiff. As soon as plaintiff reached the vehicle, he was forcefully grabbed and told that he was being placed under arrest. Plaintiff was patted down and placed in handcuffs. Plaintiff made defendants aware of prior shoulder injury, and plaintiff was put in 2 pairs of handcuffs to adhere to his medical needs. Although later during the encounter, a defendant police officer would yank and squeeze forcefully on plaintiff's arm over and over unnecessarily. And once again, we've seen the video. He's put in 2 pairs of handcuffs. It's behind his back, but he has about this much space. We could see both wrists to his side from the front view. Certainly not torture cuffs. And yes, officers do yank and squeeze on your arm. It's called forceful compliance. If you are pulling away, they will squeeze. If you are trying to walk away, they will squeeze. They will yank. When you're under arrest, you do not get to decide where you go. The police do. Plaintiff was soon surrounded by 4 different police officers, now defendants, where he continued to protest that they had no valid reason to detain or arrest him. Bork accused plaintiff of being on drugs based on the color of his skin. Plaintiff said he did not have a criminal record, and Bork entered his vehicle to type up a report. If I recall from the video, once again, thanks to Artie's corporate fiction for said video, it was not based on the color of his skin in general. It was based on the color of his lips. as in his lips had disappeared and were dry and cracked and disgusting. And I mean, I don't have much room to talk because I absolutely hate the feeling of chapstick, but I have lips that they don't disappear into the rest of my face. Soon after, one of the defendant officers demanded that plaintiff look only straight ahead, and when plaintiff did not immediately comply, the defendant began squeezing plaintiff's elbow, placing pressure on the ulnar nerve. Once again, he decides where you stand, which direction you're standing. You're under arrest. He can't control where you're looking, where you're turning your head, usually. But if you're turning your body, he absolutely can turn you back. Plaintiff complained about the pain and protested against needing to look in a specific direction to have an arrest effectuated on him. The defendant squeezing plaintiff's elbow said that it was within their policy to squeeze elbows for people in their custody that did not comply with random commands that would grant complete dominion over another human being, from which way plaintiff's head could turn, to his right to use speech, or when he can blink. Yeah, you made all of that up, except for it was within policy to squeeze elbows to have them situated where they wanted. The officer said nothing about complete dominion over another human being, or where his head could turn, his right to use speech, or blinking. It's almost like delete Lawz engages in hyperbole, which doesn't go over super well in court filings. And I mean, yeah, this is going to be 12b6. For those of you who are new, 12b6, Federal Rules of Civil Procedure, is a motion to dismiss for failure to state a claim upon which relief can be granted. This is going to be such a claim. But if it weren't, let's say it went to an evidentiary hearing, or to trial. The jury's going to see the body cam. It's not hard. I mean, in the motion to dismiss, well, in the answer, this is just, they're going to deny, because in an answer, in a response of pleading, it's admit, deny, or deny with explanation. They could say, we deny, paragraph 31 is denied, the cop said this. Or they could just say, paragraph 31 is denied. What? Plaintiff did experience severe pain and paresthesia from the compression of his ulnar nerve. When plaintiff pleaded for help from the surrounding defendant officers, they completely ignored plaintiff. Plaintiff told them, "You're going to be sued for failing to intervene. I'm sitting here telling you this man is torturing me. Please ask him to stop." Plaintiff was ignored by all sworn peace officers on the scene, who are now defendants. Plaintiff's elbow was squeezed for approximately 15 minutes in total before plaintiff's pain tolerance forced him to tear his elbow away from the defendant officer. Oh, so that's physical resisting? Attempted escape? Probably not attempted escape, but you admit you forcibly tore your elbow away. That sounds like the prelude to escape. At some point, defendant Torrey, the supervisor, arrived on the scene, authorized the defendant's behavior as being within their policy, Tory then stated that plaintiff should be arrested to discourage plaintiff's behavior. All the defendants on the scene knew that there was no reasonable suspicion or probable cause to suspect plaintiff of any crimes, but wrongfully believed that they were justified in detaining plaintiff for assertion of his civil rights and for refusing to cooperate with the defendant's feelings and ridiculous, unreasonable demands of a law-abiding citizen. Interference with a traffic stop is criminal. I mean, and this, I should have said this at the outset, but it almost goes without saying. In order to prevail on a civil rights case like this, at a bare minimum, you've got to be found not guilty first. The charges have to be dismissed, or a jury or a judge finds you not guilty. When you haven't even been arraigned yet, there's just no way you're going to win. Even if he prevails on the criminal case, that doesn't mean he wins this civil case, because it just means it wasn't beyond a reasonable doubt that he was guilty of this crime. It doesn't mean that there wasn't reasonable suspicion to detain him and probable cause to arrest him. That's a much lower standard than reasonable doubt. So, as long as there was reasonable suspicion and probable cause, we're good. The cops are good. Because that's what's required for the arrest. A conviction isn't required for an arrest. But it just shows how premature this lawsuit is. And it's ridiculous. Bork engaged in profiling against members of the press when he stated that First Amendment auditors had been known for dropping their phone, pulling out guns, and shooting at officers, which is preposterous and provably false. That's irrelevant. That's irrelevant. He didn't say, you did this. He didn't say, it's common. He said, it happens. But once again, that's not profiling. You're under arrest. Even if it were profiling, it's not for a protected class. In short, your civil rights weren't violated. A defendant officer said that plaintiff needed to be patted down again. Plaintiff protested that he'd already been patted down by 2 officers. The officer then spread plaintiff's legs uncomfortably wide and purposely and maliciously and with significant force struck plaintiff in the testicles with what felt like a closed fist. Plaintiff yelled in pain, "I can't believe you just hit me in the nuts." And I did not hear that on the body camera. Is he making this up? I don't know. I imagine he is. Plaintiff was forcibly placed into a police vehicle by defendants who pulled the seatbelt as tight as they could, knocking the air out of the plaintiff. Plaintiff again pleaded for help from surrounding officers, but he was ignored again. B. Sorensen attempted to get plaintiff arrested for NRS 202.487 for having his dog in a vehicle. Even though plaintiff's animal was not in unsafe conditions, plaintiff was searched and transported to the Clark County Jail, where he would not be formally charged, but only released with citations approximately 5 hours after the incident began. You got citations. That's the charge. If you weren't arrested and released, you were charged. You received the citations. I mean, this is almost like, was it Last Days of Freedom? Recently said the charges were dismissed. I just had to pay a fine, which means it wasn't dismissed. You paid a fine. You received citations. You were charged. And B. Sorensen attempting to arrest him for Charlie being in the vehicle, unless you received a citation for that or charges for that, it's irrelevant. You were arrested for other things, for interference, for battery on an officer, if I remember right. That's what's relevant. Oh. The officer's actions left plaintiff in the position where he had to pay for a ride back to his vehicle, and did pay monies for such a ride. On the arm that defendant squeezed, plaintiff was left with a severe bruise in his elbow area, continues to have paresthesia in his index and thumb, and requires ongoing medical care. Almost a month after the incident, B. Sorensen continues to harass plaintiff by warning him against violating NRS 202.487, although plaintiff has never left his pet in unsafe conditions. Sorensen continues to harass. Is that because you're following him around? If you're following him around, harassing him on the streets, and he says, "Hey, don't leave your dog in the car," that's not him harassing you. That's banter. That's you harassing him. I mean, unless Sorensen is specifically calling or emailing or hunting down delete Lawz, it's not harassment. My brain is going to break before I'm done with this. As a result of the defendant's actions, plaintiff suffered a deprivation of his rights and liberties, sustained physical injuries, and suffered physical pain, mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. At no time during the encounter with defendants did plaintiff do or say anything that would put a reasonable officer in fear for his or her safety. Funny enough, that's not the standard. The officer doesn't have to fear for their safety to arrest you. You standing too close to the officer from behind during a traffic stop is enough. Well, and then not complying with orders to move back. Following the incident, Bork claimed in a written incident report that the reason why plaintiff was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised that he was detained. A detained person's rights are only limited as to leaving. A police officer's, specifically defendant Bork's, feelings must be weighed against a citizen's rights. The defendant's behavior did not follow LVMPD's use of force policy and interactions with the public policy. As auditors love to say, policy isn't law. So it works both ways. And a detained person's rights only limited to leaving. No, no. You're not allowed to wave your arms around because when you're detained, your arms are behind your back in handcuffs. You are not allowed to walk around the scene willy-nilly. That's not leaving, but the officer can say, you stand right there and do not walk anywhere. That's allowed when you are detained. Delete Lawz does not know anything. I mean, a detained person's rights are only limited as to leaving. Source, please. And defendant Officer Bork's feelings must be weighed against a citizen's rights. Let's see. Bork claimed in a written incident report that the reason plaintiff was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised that he was detained. It doesn't say he was arrested for Officer Bork's feelings. The written report by Bork also claimed because Decastro was physically uncooperative with officers, admitted to being in trouble numerous times in the past for similar reasons, and would not even allow officers to explain to him why he was detained or placed in handcuffs, we determined that he was not a good candidate for a citation and release. Because of DeCastro's actions, it was clear that his criminal behavior would continue in the area if police did not act. And that is a reasonable assumption for Officer Bork to have made. The facts in the incident report were either fabricated or merely pretextual. Even if the facts set forth in Defendant Bork's report were true, which the video evidence disputes, not the videos I've seen, but I've watched them with a clear head and, not high as a kite. So those facts still did not give rise to a reasonable suspicion to detain plaintiff Terry v. Ohio. I'm dead. I'm dead. He's killed me. I'm dead. Terry v. Ohio is not about detention. It is about a Terry frisk where you can search, you can frisk a detained suspect for weapons. It has nothing to do whatsoever with whether or not you can detain. You'd think Mr. Terry versus Ohio would eventually learn what that case is or isn't about. Oh. Uh, Why? But those facts still did not give rise to a reasonable suspicion to detain plaintiff Terry v. Ohio, and certainly did not furnish probable cause to arrest plaintiff. Plaintiff stated early in the encounter that he had no criminal record and there wasn't any criminal behavior. At that point, a reasonable officer would have left the plaintiff alone. Bork never told plaintiff that there was an investigation or that he was interfering with it. Officer Bork having a car stopped in a traffic stop. Does delete Lawz really need it spelled out that that is an investigation? Mr. 20-year constitutional law scholar is the stupidest person on the planet. There's no other explanation. And I mean, at that point, a reasonable officer would have left the plaintiff alone. Delete Lawz was the one interfering. A reasonable person leaves the police alone when they're conducting a traffic stop. Once again, it's the Uno reverse card. That doesn't work in law. Rather, Bork only demanded that plaintiff respect Jane's privacy in public. Defendant Bork seemed only intent on preventing plaintiff from recording the police interaction. He said, "Move back." He didn't say, "Stop recording." Perhaps this is because plaintiff has recently covered several stories about LVMPD that went viral on the internet. None of them went viral. I guarantee, if anything, if the cops were aware of him, it's because the other cops he interacted with before, they might have put out a memo saying, "Hey, there's this nut job going around interfering with traffic stops and yelling and screaming and acting belligerent. Keep an eye out for him." They don't care that you have YouTube videos out. Plaintiff is informed and believes and intends to prove after conducting relevant discovery that defendant's actions in detaining and or arresting plaintiff, using force on him, and illegally searching him and his belongings was motivated largely or entirely by the following. 1. Plaintiff's position as a member of the press that records police interactions for accountability. 2. Plaintiff's negative viewpoint of police who all contribute or hold silent, the thin blue line, about police brutality. And or 3. Plaintiff's verbal protestations of the defendant's actions and plaintiff's accusation that the defendants were harassing him. I don't think any comment is needed on those 3 fairy tales. And he intends to prove after conducting relevant discovery. Like all of his cases, this one will never get to discovery. He is terrified of what will come out in discovery. He's hoping to get nuisance value go away money. But since the courts are now fully open, they're not letting frauditors get away with this nonsense anymore. There was a 2-year period where it was the golden age of frauditing because it was catch and release and the courts were so backed up that there were no consequences. That's not the case anymore. Prosecutors and cops know the game by now. The golden age of frauditing is over. Indeed, as shown on the video footage captured by plaintiff's cell and the video footage plaintiff expects to obtain from the defendant's body cams, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the detention and or arrest, excessive use of force, and subsequent searches. Therefore, there is a strong inference that the defendants were in fact motivated by one or more of the 3 factors enumerated above. We've seen the body cam. We've seen Delete Lawz live stream. He's delusional. First cause of action, 42 United States Code, Section 1983, Fourth Amendment. Against Bork, Torrey, Dingle, Sorensen, Sandoval, Doolittle, and Doe's number 1 through 25. Why not Doe's 26 through 50? So, remember at the very beginning, I said, I have a suspicion, because remember, this is a blind reading. I haven't read it yet, but I had a suspicion that 1983 would come up and the Fourth Amendment. So, let's look at the Fourth Amendment and 42 USC 1983. Oh, come on. I thought I had clicked through to Fourth Amendment. Okay. Amendment Constitution, the right of the people to be secure in their persons, houses, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, an arrest or detention are certainly seizures. So the cop, let's scroll back up. Hey, look at that. In the written report, because Decastro was physically uncooperative with officers, admitted to being in trouble numerous times in the past for similar reasons, and would not even allow officers, blah, blah, blah. We felt that we had to arrest him. In the written incident report, he was arrested for engaging with the detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after advised that he was being detained. So, once again, particularly describing, but in oath or affirmation, the written report would be under oath, that there's a affidavit submitted by the officer in support of it. It lays out exactly why, and it's unreasonable searches and seizures are illegal. That I don't think this was unreasonable. I mean, Delete Lawz was certainly acting unreasonable. The officer wasn't, at least not that I saw. Next, we look at 42 USC 1983, civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage, of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to be to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. So, what does this mean? Well, delete Lawz is using 1983 as the cause of action to claim that he was deprived of his Fourth Amendment rights. But that's just not the case. So, plaintiff refers to paragraphs, blah, 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 and incorporates, blah, blah, blah. By the actions and omissions described above, the defendants acting under color of law, of state law, in their individual capacities and as integral participants, violated plaintiffs' rights under the Fourth Amendment to the U.S. Constitution. These deprivations include, but are not limited to, the right to be free from detention without reasonable suspicion, the right to be free from arrest without probable cause, the right to be free from unreasonable search and seizure of property, the right to be free from excessive force and unreasonable force and restraint in the course of an arrest. And we've already described above why all of those don't apply because they just aren't the case. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and proximately caused injuries and damages to plaintiff as set forth above. Defendant's conduct entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against Nevada. It's unfortunate that you can't add punitive damages to frauditors to deter such conduct. Second cause of action, 42 U.S.C. Section 1983 and 14th Amendment. So it's 1983 again, but the 14th Amendment. And wouldn't you know it, that's another one that I pulled up beforehand. Let's see. I'm guessing he's going under Section 1 of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Well, that part isn't relevant. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Well, wouldn't you know it? That's the privileges or immunities clause. There's also the privileges and immunities clause in the body of the Constitution itself, not in an amendment. I can't remember if it's, I can't remember which article it's in, but that is, both of these are colloquially known as the right to travel, which sovereign citizens and delete laws love to spout. But as we know, these privileges, immunities of citizens of the United States are like, if I go to Nevada and establish residency, they can't deny me the privileges of existing Nevada citizens just because I'm new. If I sign up for the state Medicaid and would have otherwise qualified, they can't say, well, no, you just came from Utah, so you've got to wait. Nope, I don't, because you can't deny me the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That, well, the equal protection and due process clauses there in Section 1 of the 14th Amendment are probably the clauses that he is claiming these under. Because basically, what happens is through these clauses, the Supreme Court has said, well, the First Amendment says, the federal government shall not deprive, you've got the freedom of religion, freedom of the press, freedom of speech, right to assemble, petition for redress of grievances. That's one of my pet peeves. First Amendment auditors, I'm redressing my government employees. That's you don't have the right to redress. You have the right to petition for redress of your grievances. You don't have the right to say, hey, you're doing wrong, fix it. You've got the right to go to court and say, or to the city council meeting or whatever, and say, hey, they're being naughty, fix it, please. They don't have to. That they can say, hey, we don't agree with you, get lost. You've got the right to petition. That's it. That's one of my pet peeves. But through the 14th Amendment due process clause and equal protection clause, the most sections of the Bill of Rights have been held against the states. So, like, you have the right to remain silent. The federal government, federal law enforcement can't compel you to testify against yourself. But through the Fifth Amendment, as applied through the 14th Amendment, neither can the state or city or whatever. Same with the right to counsel in most criminal cases. That's applied through the Fourth Amendment. Whereas the right to a jury trial in common law for controversies exceeding $20 or whatever it is, I can't remember. That hasn't been held against the states. So a state doesn't have to give you a jury trial in a civil case unless it's state law. The federal government has to, because just about anything's going to be over the jurisdictional limit there, the $20 or $15 or whatever it is. So, but yeah, so with this, like I said, he's using the 14th Amendment. Well, the cause of action is 1983 for a violation of 14th Amendment and presumably the Fourth Amendment as construed through the 14th Amendment, it gets convoluted. And this is also against Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Doe's 1 through 25, but not 26 through 50. By the actions and omissions described above, defendants, acting under color of state law in their individual capacities and as integral participants, violated plaintiffs' rights under the Equal Protection Clause of the 14th Amendment to the United States Constitution. Hey, wouldn't you know what I said? Probably the Due Process and Equal Protection Clauses of the 14th Amendment. It's almost like it's predictable. Defendants intentionally discriminated against plaintiffs based on the color of his skin. He's whiter than I am. They commented on the color of his skin because his lips were the same color as his face. They didn't say, we're arresting you because you're brown, or because you're white, or because Decastro is a Latin name. They asked him, hey, your lips have disappeared. Are you on drugs? That's not what they arrested him for. They didn't charge him for being on drugs. So how was he intentionally discriminated against based on the color of his skin? That's nonsense. I mean, he was discriminated against based on his position as a member of the press and due to his viewpoints. No, it was based on his actions. Whether he was press or not didn't give him rights to be too close or to interfere with the stop. It's that simple. Defendants would not have harassed, detained, arrested, used force on, and searched plaintiff if he had been more like them. Yeah, they would not have arrested a fellow cop on the scene because they would have been legally on the scene. In particular, according to defendants' own incident reports, one of the facts upon which they relied in detaining or arresting plaintiff is that there were previous incidents involving members of the press dropping their cameras and pulling out guns. Choosing to detain plaintiff, a member of the press, based on alleged actions and or involvement of other members of the press and due to the color of his skin is illegal profiling and prohibited by the 14th Amendment's Equal Protection Clause and by NRS 289.510. If the defendants had been told that a man of their skin color trying to get police officers' autographs instead of photographing police interactions for accountability had pulled guns on police, it is virtually certain that defendants would never have detained, arrested, or searched such a person in the same parking lot. If someone approached a cop in the middle of a traffic stop asking for an autograph and the cop said, hey, back off, and they didn't, they probably would have been arrested. This is asinine. And once again, he keeps saying they harassed him. They did not make contact with him. He inserted himself into their interaction. It's his fault. If he had been at a reasonable distance, get a shotgun mic, get a telephoto lens. You can be a reasonable distance away and still see the pores on the officer's skin. You can get that good of a telephoto lens. You can hear the officer think with the right shotgun mic. If you had done that, the officer would not have said a word to you. It was because you were too close and you were interfering and you refused to sufficiently back up. That's it. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and proximately caused injuries and damages to plaintiff as set forth above. Defendant's conduct entitles plaintiff to punitive damages and penalties allowable under 42 U.S. Code 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against defendant Nevada. Third cause of action, 42 U.S. Code Section 1983, First Amendment. Against Bork, Torrey, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25, but not 26 through 50. I didn't. Well, I guess I should have expected First Amendment because I'm a member of the press. That gives me extra rights. I can trespass if I'm a member of the press. Said no law ever. By the actions and omissions described above, defendants acting under color of state law in their individual capacities and as integral participants violated plaintiffs' rights under the First Amendment to the U.S. Constitution. In particular, defendants retaliated against plaintiff for his speech, including his verbal protests and criticisms of the defendant's actions in investigating, detaining, and arresting plaintiffs without any basis, and his exercise of his right to refuse to cooperate in what started as a consensual encounter. Plaintiff also believes defendants retaliated against him for refusing to cooperate in a consensual encounter, which is also protected under the First Amendment. So he's saying they arrested him for exercising his right to not speak. If I'm understanding that correctly. He sure did a lot of shouting and never shut the hell up for refusing to cooperate in a consensual encounter. But when you initiate a consensual encounter with the police, as in you insert yourself into their investigation, it can become very quickly a non-consensual encounter, such as a detention, An arrest? Imagine that. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and proximately caused injuries and damages to plaintiff as set forth above. Defendant's conduct entitles plaintiff to punitive damages and penalties allowable under 42 USC 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against defendant Nevada. Fourth cause of action, 42 USC 1983, Monell and supervisor liability against Las Vegas Metro Police Department, Nevada, Torrey, and Doe's 26 through 50. Well, hey, there you go, 26 through 50. This isn't going to work for him either. The unconstitutional actions and or omissions of defendants Burke, Torrey, Dingle, Sorensen, Sandoval, Doolittle, and Doe's 1 through 25 were pursuant to the following customs, policies, practices, and or procedures of defendants LVMPD and Nevada, and which were directed, encouraged, allowed, and or ratified by policy-making officials with Nevada and the LVMPD. A. To carry out or tolerate unlawful detentions without reasonable suspicion. B. To carry out or tolerate unlawful arrests without probable cause. C. To carry out or tolerate detentions and arrests based on citizens' refusal to cooperate with consensual encounters. D. To carry out or tolerate detentions and arrests based on citizens' exercise of their First Amendment right to criticize and verbally protest deputies' actions. E. To use or tolerate excessive force. F. To carry out or tolerate unlawful searches of persons and properties. G. To carry out or tolerate discriminatory and biased policing and or racial profiling. H. To fail to institute, require, and enforce proper and adequate training, supervision, policies, and procedures concerning each of the foregoing practices. I. To fail to institute, require, and enforce proper and adequate training, supervision, policies, and procedures within the LVMPD concerning the fear experienced by people of different skin color and other minorities, including cop watching activists, when interacting with law enforcement in light of well documented, highly publicized, and disproportionate amount of violence committed by law enforcement against said groups, and the tactics that LVMPD officers should employ in dealing with said groups in light of such fears, especially where, as here, they have been explicitly made known to the officers. J. To ignore and or fail to properly investigate, supervise, discipline, and or terminate officers who have engaged in unlawful or unconstitutional law enforcement activity. And K. To allow officers to file false police reports. Defendant Nevada, LVMPD, and Doe's 26 through 50 failed to properly screen, hire, train, instruct, monitor, supervise, evaluate, investigate, and discipline and or terminate defendants Bork, Torrey, Dingle, Sorensen, Sandoval, Doolittle, and Doe's 1 through 25 with deliberate indifference to plaintiffs' constitutional rights. It's been like a week since he filed a complaint with Internal Affairs. The wiretapped phone call. Um, things take time. So even assuming the officers did something wrong, it's not fixed on the side of the road. They, to my knowledge, didn't do anything wrong. But this would be premature. Specifically, defendants that tortured me. In a country that is based on respecting constitutional rights, those officers are tyrants and a menace, and their actions are unbecoming of being called an officer. The men who watched them do what they did should have to pay for this lawsuit out of their own pockets. Plaintiff offered Bork to not sue you, take these cuffs off me, and let's talk about what we both expect from one another, cops and cop watchers. Meaning, defendant Bork had the opportunity to avoid this promised litigation. What could have been settled in a meeting will now cost the taxpayers. The unconstitutional actions of defendants Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25 were approved, tolerated, and or ratified by policymaking. Okay, that's a blank page, isn't it? Because we're on paragraph 63. Scroll down the blank page, paragraph 64. So either we missed the majority of a more than page long paragraph, or he inserted a blank page mid paragraph. Now, I'm not hallucinating, am I? You guys see this blank page too, I hope. So let's try that again. The unconstitutional actions of defendants Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25 were approved, tolerated, and or ratified by policymaking officers for defendant Nevada and the LVMPD. The aforementioned customs, policies, practices, and procedures, and the failure to properly screen, hire, train, instruct, monitor, supervise, evaluate, investigate, discipline, and terminate, and the unconstitutional approval, ratification, and or toleration of the wrongful conduct of defendants Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25 were a moving force and or proximate cause of the deprivation of plaintiffs' clearly established constitutional rights. As the supervisor on scene, defendant Tory had an obligation to ensure that his subordinates, including defendants Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25, refrained from violating plaintiffs' constitutional rights and prevented other peace officers from violating plaintiffs' rights. Because defendant Tory learned and was apprised of the relevant facts surrounding the arrest and or detention of plaintiff, the use of force on plaintiff, and the search of his person and property, and because he knew that such actions were illegal and unconstitutional, Tory was obligated to immediately terminate those unconstitutional actions, and by failing to do so, Tory is liable in his role as a supervisor. Tory said superficially, "No, you have been arrested because you've done this before, and we want to deter this behavior." He openly stated he didn't want plaintiff to film police and he would put charges on him because he is a nationally known cop watcher. LVMPD is well aware of who plaintiff is and what he does. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. No, he didn't say that you were arrested to deter you from filming the police or because you're a nationally known cop watcher. It's because You interfered with the traffic stop, and you've done it before. How hard is that to understand? And I mean, this is just delusions of grandeur. LVMPD is well aware of who plaintiff is and what he does. First off, even if they are, that's irrelevant. But second, we all know who he is, but that's because we are all degenerates who are amused by this little itty bitty teeny fraction of a community. I mean, even if, let's pretend that Delete Lawz has earned every one of his subscribers, and there are no duplicates in there, and he didn't buy any. Let's say all of that is true. I don't think any of that is true, but let's say all of that is true. So he has 110,000 subscribers, whatever it is today. Out of 345 million residents in the United States and about 8 billion people in the world. A 100,000 isn't a small number, but in comparison to either of those, it's itty bitty. I realize it's a lot bigger than my subscriber base, but I don't expect cops to know who I am. I do actually pull the "do you know who I am" crap, like at the grocery store, but it's funny because I'm a nobody. And I don't think I've actually done it since I have had a YouTube channel, but I've done it as a joke. And the people I've said it to have been in on the joke. Fifth cause of action. And let's see what under supposedly Monell and supervisor liability. I'm trying to think. I had my business orgs outline open a couple weeks ago to talk about agency law. I'm trying to think if Monell is a case that was on it. But he says here Monell and supervisor liability. He doesn't say what Monell is in here. So what exactly is he claiming? I'm not going to search for it because nobody has time for that. Yes. One is under the law. To load. need to get my better computer fixed. So, 42 U.S. Code 1981, Equal Rights Under the Law. Section A, Statement of Equal Rights. All persons within the jurisdiction of the United States shall have the same right to right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. B. Make and enforce contracts defined. For purposes of this section, the term make and enforce contracts includes the making, performance, modification, and termination of contracts, and the enjoyment of all benefits, privileges, terms, and conditions of the contractual relationship. C. Protection against impairment. The rights protected by this section are protected against impairment by non-governmental discrimination and impairment under color of state law. So, basically, this says if you wouldn't arrest a white person for this, you can't arrest a black person for this. If you wouldn't arrest a white person for this, you can't arrest a Hispanic person for this. But by all appearances except name, delete Lawz would pass as white. Like, I don't have the arrest forms, but I guarantee the box is ticked white. It's not that difficult. So there is no 1981 violation. But let me see if I can. It doesn't matter. Let's see. Okay, I don't want to search for it, so I'm not going to find the citations right now, at least. But the fifth cause of action is 42 U.S. Code Section 1981 against Bork, Tory, Dingle, Sorensen, Sandoval, Doolittle, and Does 1 through 25. In doing the things herein alleged, defendants intentionally discriminated against plaintiffs because of his race and political viewpoints, thereby depriving him of his right to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by all other citizens. Hang on. That this has absolutely nothing to do with political viewpoints. Is he trying to extend this beyond the four corners of the law of the text? That's very naughty. But once again, they did not arrest him because of his Hispanic name. Any comment about the color of his skin, watch the video, go watch Artie's Corporate Fiction. His lips, they disappeared. It made him look high. They didn't say, we're arresting you because you're Hispanic. They didn't say, we're arresting you because you look Hispanic or have a Hispanic name. They also didn't say we're arresting you because of the color of your lips. They said your lips are white, or your they commented on the color of his lips and said are that makes us suspect you're on drugs. There's a difference. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and proximately caused injuries and damages to plaintiff as set forth above. Defendant's conduct entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against state defendant Nevada. Sixth cause of action, assaults against all defendants. No. In doing the things herein alleged, defendants intentionally and without consent or legal justification attempted to make a harmful and or offensive physical contact with plaintiff and thereby placed plaintiff in fear of an imminent harmful or offensive contact. Well, he's got the definition of assault, at least. But legal justification. When you arrest someone, you have the legal justification to touch them. It's hard to arrest someone without touching them. As a direct and proximate result of defendant's conduct, plaintiff was harmed. Defendants, Nevada and LVMPD, are vicariously liable for the acts and omissions of their employees acting in the course and scope of employment, pursuant to NRS 41.032. The conduct of the individual defendants was malicious and oppressive, in that they intended to harm plaintiff and deprive him of his rights, and their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. I mean, he says they're despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety. If I'm representing the defendants, Your Honor, this moron was in handcuffs. Our policy is to always have our hand on their elbow when they are handcuffed to steady them, because if they fall, they don't have hands in front of them to break their fall. It's a safety concern. So they were touching him in an attempt to keep him safe. It's almost like they had a legally justified reason for touching him. Imagine that. Seventh cause of action, battery against all defendants. In doing the things herein alleged, defendants intentionally and without consent or legal justification touched plaintiff in a harmful and offensive manner. That's the definition of battery. The analysis is going to be the same. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment, pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive, in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Every time he writes despicable, I think of I'm pretty sure it's Daffy Duck. It might be Donald Duck, but I'm pretty sure it's Daffy Duck. Despicable. Eighth cause of action: false arrest and imprisonment against all defendants. In doing the things herein alleged, plaintiffs or defendants intentionally arrested and or detained plaintiff without a warrant or other legal justification, and in doing so restrained plaintiff, handcuffed him, and placed him in patrol cars against his will, thereby depriving him of his freedom of movement. They did without warrant. Funny enough, they don't need a warrant if they witness the crime. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment, pursuant to NRS 42.005. The conduct of individual defendants was malicious and oppressive, in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Ninth cause of action: invasion of privacy. As a frauditor would be all too quick to tell you, you have no privacy in public. During the incident giving rise to this action, plaintiff had a reasonable expectation of privacy in his personal affairs, including the contents of his personal belongings, such as vehicles. Page, pockets, wallets, cell phones, and other electronic devices. Did they search his phone? In doing the things herein alleged, defendants intentionally invaded and intruded into plaintiff's personal and private affairs by searching his belongings without a warrant or other legal justification. Defendant's invasion of plaintiff's privacy would have been offensive to any reasonable person. As a direct and proximate result of defendant conduct, plaintiff was harmed. Defendants Nevada and LVMPD are vicariously liable for acts and omissions of its employees acting in the course and scope of said employment pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive, in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Police have the right to search you incident to arrest. If you are being arrested, you are not allowed to bring certain objects into jail or into the police department, into the holding area. If you do something that finds you arrested, you are going to be searched. It is not an unlawful search. Now, if they forced him to unlock his phone so that they could search it, that could have been. I didn't see it. Now, his vehicle. In plain view, they can look through the windows. That is not an unlawful search. Finding Charlie, his dog, that gives them exigent circumstances to enter the vehicle for the safety of Charlie, to remove him from the vehicle so he doesn't overheat and die. So if you don't want the cops to have any reason to go into your vehicle, don't leave your dog in it when you have a possibility of being arrested for your actions. Common sense, not legal advice. That's just common sense. It's exigent circumstances, safety of Charlie, free Charlie. Not 10th cause of action, negligence against all defendants. The individual defendants owed plaintiff a duty to use reasonable care in connection with parties' interactions as described herein. In particular, such defendants had a duty to carefully investigate any criminal activity, to use care to avoid subjecting plaintiff to an illegal detention, arrest, seizure, or retaliation for exercise of free speech, free press, or petition for redress of grievances, use of force, or deprivation of any of the other rights enumerated herein, and to use reasonable care to avoid engaging in biased policing or racial and political affiliation profiling. In doing the things herein alleged, defendants breached the applicable duty of care by acting unreasonably, carelessly, negligently, and or recklessly. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Prayer. Plaintiff prays for damages as follows. For compensatory damages in an amount according to proof. For punitive damages in the amount of $5 million or in an otherwise laughable amount sufficient to punish defendant's conduct and deter similar conduct in the future, pursuant to 42 U.S. Code, Section 1983. No punitive damages are sought against defendant Nevada. For all applicable statutory penalties, for attorney's fees pursuant to 42 U.S. Code, Section 1988, even though he is pro se, no attorney, for costs of the suit, for such other and further relief as the court deems just and proper. Demand for a jury trial. Plaintiff hereby demands a jury trial. Certificate of Interested Parties, Local Rule 7.1-1. The undersigned pro se party certifies that the following may have a direct pecuniary interest in the outcome of this case. Any employee or contractor of the state of Nevada, due to the state of Nevada being a defendant. Any pro-police organization, due to the political affiliation of the declaration. I declare under penalty of perjury that the foregoing is true and correct. Dated April 17th, 2023. Respectfully submitted. Jose Decastro. Pro se. And that's going to be 12B6 very quickly. Enjoy it while it lasts. And we have document 3 is the summons. A lawsuit has been filed against you within 21 days, blah, blah, blah. So that's the summons. Document 4. Dear litigant, you are notified that the above case number has been assigned to your action. Blah, blah, blah. So it's basically document 4-1. Notice regarding temporary suspension of local rule IC 2-1C, submission of manual documents by email. So basically, due to COVID, you don't have to file with the court clerk in person. You can file by email for certain things. And finally, document 1, which is delete Lawz asking for ECF filing privileges. Hey, 1 hour, 56 minutes. We kept it under 2 hours. I'm impressed. That means I have half an hour until the finale of The Mandalorian starts, which I'm excited for. I am hoping to see Grand Admiral Thrawn and hoping that none of the characters I want to see going forward dies. So, with that being said, like I said, I think this is a clear, frivolous lawsuit, just clearly frivolous. It's what 12b6 was made for. It's what governmental immunity was made for. It's what qualified immunity was made for. It's not going anywhere. It'll be dismissed long before it goes to discovery. So delete Lawz will actually not be subject to the invasions of discovery, unfortunately. So I gave my roadmap last video where I said, well, I'm going forward. I need to do the finance YouTubers lawsuit concerning FTX. Well, I still need to do that. It got worse. I still need to do the Onision lawsuits because we've got to have some dancing banana. And I thought I was done with this, but Brunson, I don't actually know what the case is called anymore because it's a different case. But for those of you who watched the Brunson v. Adams delusion, I thought it was over. Like, I even closed down the docket of it. It's not over. So I'll be covering that soon. So please like, share, subscribe. Join me for some of my other content. Unfortunately, my delete Lawz content is what gets all the views. I think it tends to be the least interesting of my content. So please join me for the more interesting stuff. And I will see you guys soon, I'm sure. Thanks for joining me. Bye-bye.